Good morning and welcome to this year's annual Public Procurement Law Update. Our speakers today are myself, Chris Tayton, and my colleague Emma Butcher. We're both procurement law specialists at the law firm Clarkslegal LLP. And we're delighted also to be joined by John Williams of Strategic Proposals. The last 12 months have been like no other. Public procurement, like all aspects of life, has been profoundly affected. We've had Brexit, we've had the proposed reform of the whole of public procurement law, we've had the pandemic, and we've also had the usual legal developments we see in any normal year. The topics we are covering today are set out on this slide. We have so much to cover that we'll jump straight into it, with Emma starting with what Brexit means for public procurement.
Thanks, Chris. So I'm going to talk to you first of all about the current position as of the 1st of January. In case anybody missed it, we left the EU. Officially, the transition period ended at 11 p.m. on the 31st of December. So we're now into a new world of UK public procurement rules, but I think it's safe to say that for the time being, at least, they are not that different from the EU public procurement rules. So the snappily titled Public Procurement Amendment, etc. EU Exit Regulations set out the transitional provisions. Some of you may be involved in tenders which started before 31st of December and are still ongoing. For a period, we're going to have something of a hybrid regime, as the amendment regulations provide that the EU rules will continue to apply to any tender started before 11 p.m. on the 31st of December until that tender is concluded. The same also applies to framework agreements. So any framework agreement which was concluded before the 31st of December, the EU rules will continue to apply to call-off contracts awarded under that agreement. So if you're on a 4-year framework that was only concluded last year, then the EU rules are going to be around for a little while yet. In relation to all new UK tenders from the 1st of January onwards, then the public contracts regulations, the concessions contracts regulations and the utilities contracts regulations all continue to apply, but with some amendments. The UK now has its own financial thresholds over which the full regime applies. They were set in December, and for the time being, they're exactly the same as the previous EU thresholds. So we've got no change to those due until the 1st of January next year, and any new proposal thresholds will be laid before Parliament by the 1st of November. Any references in the old regulations to advertising and placing notices in OJU is now replaced by the new UK Finder Tender Service. And for those of you who've already used it, you'll see that it's very similar looking to OJU. The UK is now a party to the WTO's Government Procurement Agreement, or GPA, in its own right. Previously, we were only a party by virtue of our EU membership. The GPA is not as extensive as the EU regime, but does contain some of the same key principles, such as non-discrimination and transparency. Where it is much more limited is in terms of remedies and enforcement. For example, no standstill periods, no suspensions of the contract award. The structure of the GPA is that it has the main part of the agreement, which sets out the principles, and then it has the schedules, which set out the extent of the coverage for each party. And the schedules that we have agreed are exactly the same as those that we previously had through our EU membership. So again, no real change at the moment. As well as the GPA, we also now have the TCA, which governs the relationship between the UK and the EU. It goes a bit further than the GPA, and it protects UK businesses who are based in the EU from being discriminated against as a result of the fact that they are UK owned, and it also works the other way around, provides that UK authorities must not discriminate against EU-based suppliers. Once again, no real immediate changes with regard to procedure. If you're an authority, just continue to comply with the current UK law. If you comply with that, then you'll be complying with the TCA and the GPA. There are a few minor amendments in relation to utilities tenders and abnormally low bids. And the Crown Commercial Service has published a PPN number 2 of 21 just at the beginning of this month, which summarises the effect of those agreements for contracting authorities. One of the changes which has been brought about by Brexit is to below threshold tenders. Previously, authorities tendering a below threshold contract did not have to comply with the full regime, but if the tender had the potential to attract cross-border interest, then you were still obliged to comply with general EU treaty principles of equality, transparency and proportionality. This no longer applies in relation to tenders which take place in Great Britain, so the scope for challenging below threshold tenders is very much reduced. Important to note that the obligation does still apply if you're doing a tender involving services into Northern Ireland or goods as a result of the Northern Ireland Protocol. Again, we've got a new PPN on below threshold procurement post-Brexit, which is worth a read. This confirms that authorities do have more freedom now in relation to below threshold contracts. And in particular, you can, where appropriate, consider reserving the procurement by supplier location. So you can restrict to only UK bidders, for example, or you can restrict to a single county. What you're not permitted to do is restrict amongst nations of the UK. So you can't say English bidders only. No Scots or Welsh welcome, not allowed. Alternatively, you can consider restricting bidders to a certain class of bidders, so SMEs only, for example, or voluntary community and social enterprises only. The PPN does make clear that you still need to ensure that you're using good commercial judgment and that you're still achieving good value for money. And you do, of course, still have to comply with the obligations in the public contracts regs, which apply to below threshold tenders as regards to publishing the opportunities and notices. And finally, in this section, I talk about the new social value model, which was introduced in late 2020. It applies to new procurements from the 1st of January again. Obviously, the public sector has already been expected to maximise social value through procurement, but there was a concern that only lip service was really being paid to this in the past. So under the new rules, social value criteria have to account for a minimum of 10% of the total score, and a higher weighting can be given if appropriate. And this is designed to ensure that the social value criteria do actually have an impact on the scoring of the bids. There's a number of different criteria that you can consider, and the new one obviously for this year is COVID-19 recovery. If you're a bidder, you need to really give some serious consideration now to how you're going to demonstrate that you can meet the social value criteria given the new weightings and how you can prove it. You probably need to be looking, for example, at what policies you've got in place, what examples of your work in this area you can talk about, what kind of CSR initiatives you might have, and how you're going to measure all of this, maybe thinking about KPIs, reporting in these sorts of areas. It's worth noting that if you lie about how you're meeting your social value criteria in your bid, then you risk being disqualified. So be a little bit careful about what you say. And you might want to consider raising clarification questions to better understand what the authority is looking for and how they're going to assess the social value criteria, given that it's all fairly new at the moment. If you're an authority, then you also need to think about your approach. Are you going to have a standard set of social value criteria, or are they going to vary from contract to contract? What themes are most important to your authority and why? And always remembering that criteria always need to be capable of being objectively justified. The social value model rules only apply at the moment to in-scope bodies, which is mainly central government departments and certain other national authorities such as the NHS. Local authorities don't have to follow the model, but many might choose to adopt it as well. So again, we've got the PPN and it's worth having a read of that to clarify the changes.
Thank you, Emma. Next, we are going to look at what's in store for the future. On the 15th of December last year, just over 2 weeks before Brexit happened, the government published an 80-page green paper setting out its proposals for the future of public procurement in the UK. Public procurement was one of the targets of the Leave campaign in the lead up to the 2016 referendum. They blamed the EU for what was perceived as an expensive, substandard and ineffective procurement system. We always felt some of the criticisms were unfair. Many of those alleged problems were complications of our own making, which the UK government already had the power to change. Well, the architects of the Leave campaign are now in government, and the Green Paper is a very detailed document setting out their proposals for how public procurement should operate in the future. Note, NHS procurement is not covered in the Green Paper, and separate work on that is already ongoing. Defence procurement is included, but the Ministry of Defence is separately consulting on specific defence requirements. Some of the proposals are proving very controversial, certainly in the legal profession. Today, we'll only have a time to do a whistle-stop tour of the main proposals. So on the next slide, the government starts with a proposal to enshrine in law 6 principles of public procurement. They are the public good, value for money, transparency, integrity, fair system of suppliers, fair treatment of suppliers, and non-discrimination. Of course, many of these are already part of procurement law or government guidance. By enshrining them in legislation, these will need to form part of all procurement decisions as a matter of law. Public bodies will also be obliged to comply with the government's National Procurement Policy Statement. This will be a separate document published by the government of the day, setting out national priorities for public procurement. This will include the economic, social, and environmental outcomes public bodies will expect it to achieve in public procurement. It will also mean that public bodies have to publish their annual pipelines of planned procurements for a minimum of 18 months, but ideally 3 to 5 years. This will be very helpful business intelligence for bidders. Public bodies will be required to benchmark their own procurement capabilities against relevant standards. This is to ensure that all public bodies have appropriate capability to run successful tenders. So turning to the next slide, one of the main criticisms of public procurement is that it is too complex. There are too many regulations, there are too many different procurement procedures, too much time is wasted trying to understand the different rules and procedures. I've listed on this slide the 4 main procurement regulations which govern the different areas of procurement in the UK. There are many differences between the different regulations, but there is also a substantial overlap. The government's proposal is to dispense with 4 separate regulations and consolidate them into a single piece of legislation. It would be based on the public contracts regulations, as these are generally most well known, but it will retain some of the benefits of the other regulations, such as the flexibility allowed in the utilities contracts regulations. At this high level, the proposal sounds very sensible. However, the text of the new legislation has not been provided, and until we've seen it, we simply won't know whether it's a good idea. One specific simplification the government has announced is the intention to reduce the number of different procurement procedures. Put simply, there are currently too many. This slide lists the 7 procedures currently available. Some are rarely used. In 2017, there were only 3 procurements using the Innovation Partnership procedure and 5 involving design contests. This next slide lists the new procedures the government is proposing, cutting the list from 7 down to 3. The government wants to retain the open procedure and extend its use for suitable defence contracts. The government then proposes introducing a new procedure to be called the Competitive Flexible Procedure. This will be based on the procedure currently used for light touch regime tenders, where greater flexibility is allowed for the procurement of social, health and other services. This allows public bodies to decide their own procedure for running tenders to meet their commercial needs, provided certain minimum requirements are met. It will also mean that light touch regime tenders will no longer be needed. And finally, the government proposed introducing another new procedure, the limited tender procedure. This will be based on the current negotiated procedure without prior publication. It's only available in limited situations where procurement is justified without prior advertisement. The model will be extended to cover urgent procurement in times of crisis, which I'll come back to later. From a legal perspective, the biggest change will be the reform of how procurement decisions can be challenged. First up, we'll see the abolishment of the requirement to provide individual debrief letters to each bidder under Regulation 96. These are hugely unpopular and time-consuming, with public bodies spending considerable time trying to explain the comparative characteristics and relative advantages of the winning bidder. Instead, the government is proposing requiring bidders to publish the following information before standstill period starts: bidder identities, basis of award decision, basic disclosure of tenders submitted, evaluation reports, basic evaluation disclosure information. There's not much detail of what will be needed to be included under these general headings. The Green Paper does say bidders will be able to access the information on the evaluation of each bid under new transparency provisions and clearly be able to see why they are unsuccessful and the relative advantages of the winning bid. This suggests that bidders will receive much more information up front. In our experience, that's likely to increase the likelihood of challenge, but the government seems to think otherwise. Significant changes are proposed to the procedure for challenging procurement decisions. The government recognises that the current system is rigorous, thorough and trusted, but this is achieved by the current system being lengthy, expensive and complex. The government wants to reform the court process by accelerating the determination of claims, so that default position is that mistakes in the procurement process are put right, and there is a move away from lengthy claims where bidders are compensated in damages for the loss of profits they would have earned on the contract. This next slide contains a list of the changes the government is proposing. These are all aimed at shortening the process and getting claims decided more quickly. A new expedited trial process based on existing fast-track system with more active case management by the court, encouraging the use of courts outside of London to build more capacity in the system, a presumption that certain claims will be decided just on the papers without the need for involving witnesses and disclosure, which adds time, imposing fixed timescales for dealing with statements of each party's case, and also contracting authorities will be encouraged to undertake an internal review by staff not involved in the procurement before the court proceedings start. Said like that, these changes all sound sensible and likely to revolutionise procurement challenges by both improving access to justice and reducing costs and time. But the government has always had the power to make these changes. This is not a result of Brexit. The feeling is that if reforming procedure was this easy, it would and should have been done some time ago, and it's questionable whether this will achieve the outcome the government is hoping for. Assuming, however, that the procedural changes will radically reduce the timeframes for procurement challenges, the government also intends reforming fairly radically the available remedies for bidders who win claims. Gone will be the large damages awards for loss of profits. Instead, bidders will be limited to recovering 1.5 times their cost of bidding, plus their legal fees. A formula will be established to quantify this claim to provide consistency in calculations, particularly where costs are incurred in-house. Whether many bidders would bother with expensive and risky litigation to recover their bid costs is yet to be seen. Damages will still be available in specific cases, including contracts awarded without advertisement, such as crisis procurement, and where malfeasance is shown. The government is expecting a decline in the need for applications to lift the automatic suspension, because the time savings under the new procedure will mean public bodies will be content to wait the outcome of the claim. Where public bodies do want to enter the contract and be released from the automatic suspension, the government is proposing a new legal test to replace the current rules. The government is proposing a procurement-specific test in which the court will be required to balance the following factors: the public interest, urgency, the upholding of the regulations, the impact on the winning bidder against the right of the claimant to win the contract, and the availability of alternative remedies. There is so little detail about this proposal that it is hard to express any view on whether it is an improvement on the current rules, which are well known and based on many decades of case law. So I've only had time to run through the headline proposals contained in the Green Paper. There are a number of other important points, including changes to the way public bodies can amend and extend contracts. If you want to read the full proposals, you can access a copy of the document on the government website, and you still have time if you want to have your say. The closing date for the consultation is the 10th of March this year. I'll now hand back to Emma to talk about the rules on urgent procurements, which have been in the spotlight during the pandemic.
Thanks, Chris. So 2020 was an unusual year for procurement. We saw a very large number of contracts awarded without competitive tender in response to the COVID-19 pandemic. The previously little used emergency powers, which are contained in Regulation 32(2)C of the Public Contracts Regulations, were suddenly being exercised frequently, particularly in certain sectors like the healthcare sector, to award contracts for PPE, testing, consultancy, and more. The text of Regulation 32(2)(c) is up on the slide there. And just to break it down, the individual requirements are that the procedure can be used only insofar as it's strictly necessary, where there is extreme urgency brought about by events unforeseeable by the contracting authority. The time limits for the usual procedures cannot be complied with, and the extreme urgency is not attributable to the contracting authority. All of those criteria must be met in order to rely on the exception. Given the number and the size of the contracts that we saw awarded during 2020, it's not surprising that we also saw a number of challenges, and this is an area which has been keeping us personally very busy. One of the big challenges to be brought was diagnostics AI against the Secretary of State for Health and Social Care. This case was brought by an unsuccessful supplier in a contract for lab testing of COVID-19 tests. Sorry, the slides just gone on there. There was no regulated tender run, and the supplier was invited to submit a proposal, as was one other supplier to whom the contract was ultimately awarded. Diagnostics AI alleged that the evaluation of the winning bidder's proposal was flawed, and that they had also breached duties of equality and transparency in failing to provide information about how the bids were going to be evaluated. The case was settled just before trial for a sum of $2 million plus costs, so quite an expensive outcome for the government there. The other cases which have been featured in the press are a number of related challenges brought by the Good Law Project, which is a public interest organisation. Firstly, they have brought challenges to the award of 4 specific PPE contracts, where in each case the supplier is alleged to have little or no experience in the PPE sector. And the claims have been brought by way of judicial review, because the Good Law Project is not itself an economic operator who can bring a claim under the regulations. The awards are challenged on various grounds, and permission to proceed has been granted on some but not all of those grounds. And the denied grounds are currently subject to an appeal. So we'll have to wait and see exactly what happens with that one and report on it in a further update. But separately, the Good Law Project has also brought challenge to the Department for Health's failure to publish contract award notices in respect of various PPE contracts within the prescribed 30-day time limit. And judgment in that claim was given last Friday in favour of the Good Law Project. The Department for Health was found to have breached its obligations, and the court emphasised the importance of transparency when relying on the Regulation 32 exception. In November 2020, the National Audit Office published 2 reports, one which looked at the government's public procurement during the pandemic generally, and the second looked specifically at PPE contracts. The reports highlighted a number of criticisms, including in particular the lack of records documenting the justification for using Regulation 32, lack of records documenting the reasons for awarding contracts to particular suppliers, and the lack of checks regarding conflicts of interest. At the beginning of this month, the Crown Commercial Service published a new PPN on the use of Regulation 32, and this highlights the particular need for a clear paper trail and records documenting the reasons. It seems that this is probably trying to address some of those criticisms from the National Audit Office reports. We're now obviously almost a year into the pandemic, so the scope for use of Regulation 32 in relation to pandemic-related contracts is now somewhat reduced. However, for authorities, there are a number of lessons to be learned for the future if you ever seek to rely on this again, subject to, of course, any reforms which Chris will now talk to you about.
Thank you, Emma. So turning back to the Green Paper, we now look at how the government plans to regulate urgent tenders in the future. And as Emma's mentioned, anyone who's read a newspaper in the last year will have seen commentators lining up to criticise the government's handling of PPE procurement. And this has had a profound effect on the government, and it's not surprising the reform of these rules is high on the agenda. The proposed rules will give the Cabinet Office the power to declare a crisis if they believe a national or local emergency exists. Guidance is included in the Green Paper of what the government considers to be a crisis. That would be an event which clearly exceeds the dimension of harmful events in everyday life, and which substantially endangers or restricts the life or health of people, or where measures are required to protect public morals, order, or safety, or where measures are required to protect human, animal, or plant life or health. Contracting authorities will also have the right to submit to the Cabinet Office if they believe a crisis should be declared. Potentially, these are very wide categories, and the Cabinet Office's decision will no doubt be susceptible to challenge if it was felt they'd exceeded their powers. Once the Cabinet Office has declared a crisis, the procurement rules will change fundamentally. There would be no need to advertise the procurement, although the contracting authorities are still obliged to consider whether there is time for some level of competition. The contracting authority will still have to publish a notice of the decision to award the contract. However, there will be no automatic suspension, even if a dissatisfied party issues legal proceedings. Instead, where proceedings are issued, the dissatisfied party will be able to claim damages for loss of profits, not just the 1.5 bidding costs which are otherwise proposed. They could also seek an order that the awarded contract be shortened or declared ineffective. So that covers what we have to look forward to in the future. Next, we'll be looking at the key developments over the past 12 months, starting with Emma looking at last year's rail franchising litigation.
Thanks, Chris. So this is important because it was probably the largest ever procurement challenge brought. It was brought by a number of rail franchise operators against the Department for Transport and has been going on for a very long time, and judgment was finally handed down in June last year. The claims arose out of 3 tenders for the South Eastern, East Midlands and West Coast rail franchises. There were a number of grounds of challenge, but the biggest centred around the issue of pensions liability. Prior to the tender, there had been some uncertainty over whether there would be any future pensions liability for the Department of Transport as a result of an investigation that had taken place by the pensions regulator. And as a result of this, the tender provided that the majority of the risk as to any future pensions liability would pass to the successful franchisee, and that they needed to cost this into their bids. The rules of the tender stated that bidders must not propose any amendments to the contract terms, and that if they did, this would result in their bid being deemed non-compliant. So the claimants comprised a number of different rail operators who decided that they were not prepared to take on that pensions liability, and they each submitted a bid which proposed alternative terms despite that warning in the tender. Their bids were then indeed disqualified, and the claimants then brought claims alleging various breaches of general EU principles and of specific railway sector regulations as well. The High Court found fully in favour of the Department for Transport and decided that there had been no breach of general EU principles. First of all, it decided there was no breach in the Department for Transport seeking to transfer that pensions liability in the first place. There was nothing in UK law which prevents such transfer of risk. Secondly, they decided it wasn't necessary for the tender to spell out exactly when a discretion to disqualify will be exercised. It should be assumed, they said, that the discretion will be exercised in a rational and proportionate manner. And finally, the actual decision itself to disqualify was found to be lawful. It was noted that there was a high risk of challenge by other bidders if they hadn't disqualified, and that they were entitled to exercise the discretion as they did. So a resounding win for the Department for Transport on that one. The next couple of cases that we're going to look at are on the issue of timing. Timing is obviously always a crucial issue in public procurement claims. As we all know, bidders only have 30 days to bring a claim, and that runs from the date of knowledge, the date when they knew or should have known that a breach of the regulations had occurred. The court does have the power to extend time by up to 3 months, but it will only exercise that power rarely in exceptional circumstances. So of the 2 cases last year that looked at timing, one came down in favour of the bidder and the other didn't. The first was Riverside Truck Rental in Lancashire. In this case, the bidder had challenged the outcome of a tender and had alleged 4 different breaches of the regulations. One of their complaints was about a lack of clarity in the ITT, and a second complaint was about the way that criteria had been applied by the authority. The bidder had brought their claim within 30 days of the date that it became aware of its final complaint, but they were out of time on the first 2 complaints. And the court said there's no good reason for us to extend time in relation to those, and those claims would be struck out. It's always really important for bidders to remember that if they have a concern about something that's in the ITT documents, they must challenge it at the time. It's no good waiting until you find out if you've won or not, and only then challenging. By that point, you're out of time, as this case demonstrated. The second case was the Bromcom Computers case, and in this one, the court did go the bidder's way. Here, the complaint was about the way in which the bid had been scored, and the initial standstill letter had given bidders their scores, but had insufficient information regarding the reasons. So the bidders sought more information, and the information was initially provided orally via 2 virtual meetings that were held on Microsoft Teams. The meetings were said to have been quite heated, with people talking over each other, and there were technical difficulties with at least one of the meetings as well. And then finally, about 3 weeks after the meetings, the authority also provided a written response, which largely provided the same information that had been given orally at the meeting. And then the bidders started their claim. So the question was, when was the date of knowledge? Was it the date of the virtual meetings when the information was provided orally, in which case the claims would be out of time? Or was it the date that the information was provided in writing in the letter? The court decided that the nature of the meetings was such that the bidders could not have been expected to take in and properly assess the oral feedback they'd been given. The meetings were not structured and weren't methodical, and the fact that they took place virtually was also a significant factor. For an authority, it's always best to provide information in writing in any event, but obviously the nature of the meetings was significant here. If it's a more formal structured meeting, then the date of knowledge is likely to run from when the information is provided verbally. So bidders, if you're given information verbally, make detailed notes of anything that you're told and take early legal advice. A quick case about who can bring a claim. Claims under the public contracts regulations can only be brought by economic operators, so bidders, as I mentioned earlier. Sometimes other organisations like the Good Law Project can bring a judicial review if they have sufficient standing, but they can't bring a claim under the regulations. The community R4C case concerned an extension to a waste disposal contract from 2016. The CR4C was a pressure group, and they were alleging that the contract should not have been extended as it was really a new contract which should have been put out to a fresh tender. The claimant was an informal association. It had been set up in mid-2015 and registered as a society in February 2016. And its slightly tenuous claim was based on an argument that had the contract been properly advertised, they would have formed a consortium with an appropriate supplier to bid for the contract themselves. The court didn't accept that and decided that they weren't an economic operator at the time that the tender took place, so no claim. And the final case which I'm going to deal with today is FP McCann and the Department for Regional Development. This case doesn't really contain any new principles, but it's just a useful illustration of how the court will calculate damages. The court will make various assumptions, which I've put on the slides there, one of which is that the tenderer would have actually won the contract, and then an assumption that they would have been successful in delivering it. And then the court will discount the award of damages to reflect the fact that those things might not have happened and the contract might not have been delivered successfully. So no real new principles, but a useful illustration of how the court will determine damages if a bidder can successfully establish that there's been a breach.
Thank you, Emma. Next, we look at the very recent case of Akia Hayward versus Local Pensions Partnership Administration. This involved a short point of law which had not previously been considered by the court. As you'll know, Regulation 95 suspends a public body's entitlement to enter a contract with a winning bidder if legal proceedings have been issued. In this case, Local Pensions issued a contract award notice stating that Akia had been unsuccessful. Akia disagreed and issued legal proceedings challenging the award. Local Pensions then decided to rewind the tender and reevaluate all the bids using a new evaluation panel. Unfortunately for Akia, this did not change the outcome and they were still unsuccessful. Local Pensions then issued a new contract award notice, and the issue for the court was whether the automatic suspension in force under the existing legal proceedings prevented a contract being entered under the new contract award notice. The court held that it didn't. The suspension under Regulation 95 only applies to the contracting authority's decision to award the contract which is challenged in the legal proceedings. The new contract award notice in this case involved a new decision. That was not therefore the decision challenged in Ikea's claim form, and so it was not subject to the automatic suspension. Next, we look at a case where a public body abandoned a tender after notifying the bidder that it had won, but before entering the contract. The bidder was Ryehouse Limited, which is part of the Ryden Group of companies. Another group company, Ryden Maintenance, had been involved in the installation of the cladding at Grenfell Tower and were implicated in the disaster. The contract award notice confirmed that Ryehouse were the successful bidder, was met with vociferous public objection, including by Jeremy Corbyn and Emily Thornburg. It also coincided with the construction company Carillion going into administration, which put the spotlight on the award of public construction contracts to the private sector. Over the next few months, the NHS Trust revisited the project. They produced a report giving 4 reasons why the contract shouldn't proceed. The first was that the financial position of the NHS Trust had substantially changed since the tender was initiated in 2016, so they no longer needed to engage a joint venture partner such as Ryehouse. They also gave as a reason that the involvement of Ryehouse would result in a lack of stakeholder support. The court determined that Ryehouse link with Ryden Maintenance was not the main reason for the abandonment. The main reason was a change in the NHS Trust's financial circumstances, and this was a valid reason for abandoning the tender. The court did say, however, that if Ryehouse had proven that the tender was abandoned because of the Ryden link, they would have won the case. This would have breached the duty owed to Ryehouse to treat them equally with other bidders and not discriminate against them. Next, we look at a case which reinforces the critical importance of getting your court documents right when you issue legal proceedings. As mentioned earlier, procurement challenges are subject to very short deadlines. You generally have 30 days from becoming aware you have a claim to issue legal proceedings. After 30 days, your claim will become time-barred. Often, claims are prepared on limited information. New information and documents may be received after the issue of proceedings, such as evaluation notes, which may provide further grounds for bringing claims. Genuinely new claims are fine. The problem is with claims that could already have been asserted in the original claim, even if more relevant information was received later. Those might be time-barred. In this case, Accessible Orthodontics, the contracting authority objected to an application to amend a claim for this very reason. The court will look at the nature and extent of the breach now alleged to see whether it is a type of claim previously made. In this case, the bidder had claimed in their legal proceedings that their tender had not been evaluated in a transparent way. Fortunately for them, the new claim was just a further example of this type of claim, so was not statute barred. But this does emphasise the importance of making sure all relevant claims, apparent from the documents available at the time, such as the contract award notice, are addressed in the court proceedings. And turning now to my final slide, and we end with the usual selection of cases where public bodies have applied to court to lift the automatic suspension, which comes into play after proceedings are issued and prevents contracts being awarded. Those who have listened to previous annual updates will know we always cover a handful of these cases. Applications to lift the automatic suspension are hard, but not impossible for a bidder to win. This year has been a very strong year for public bodies. We think they won all applications to lift suspension that went to court in the last 12 months. First, to recap on the test the court applies. This is the long-established American Sinamid test. First, the court looks at whether there is a serious issue to be tried. This requires the bidder to prove they have an arguable case. It's not a high hurdle, and they do not have to prove they'll win at trial. Next, the court assesses whether the claimant can be adequately compensated in damages. If the court decides the bidder can be compensated in a money award rather than being awarded the contract, the court is likely to lift the suspension. And as part of this test, the court will consider it's fair to limit the bidder to the remedy of damages. The court will also look at the position from the public body's perspective. Could it be adequately compensated by a money award if the suspension is kept in place correctly? Where this does not provide a decisive answer, the court will look at where the balance of convenience lies. Which outcome carries the least risk of injustice? The court will also consider the public interest at this stage. So let's quickly look at this year's cases where the court has been asked by a public body to lift the automatic suspension. First is the Mighty versus Secretary of State for Justice case, which involved the tender of a facilities management contract for the UK courts building. The court applied the usual test of listing suspension, and none of Mighty's arguments that it couldn't be adequately compensated in damages was successful. A novel point run in this case was that the public interest was in favour of upholding the suspension because of the high risk of contract failure. Mighty claimed that the winning bidder's bid was much too low and was bound to fail. They tried to argue that the public body's own case supported this, as they accepted the case involved a serious issue to be tried. However, the judge was not persuaded on the evidence that there was a serious risk that the contract would fail. The public body had referred the bid to the Cabinet Office for Complex Transactions team, who would approve the transaction as viable. The next suspension case is Neology UK Limited versus Newcastle upon Tyne. This case involved a bold application by the bidder for summary judgment. And again, the public body also applied to lift the automatic suspension. The bidder tried the usual arguments that it could not be adequately compensated in damages, but was not helped by having included a very precise figure for its loss of profits from the claim. The court rejected its argument that the alleged unquantifiable damage to reputation meant that the suspension should remain in place. And there was a similar outcome in the two Northern Irish cases listed on this slide. If the government's assessment in the Green Paper is correct, we're likely to see less applications to lift the automatic suspension in the future. And for those that do happen, the court will be applying a new test. Until then, the law remains the same. I'll now hand over to John, who will speak about bidding in changing times.
Okay, good morning, everybody. In early 2003, I flew out to Hong Kong for a week's work with clients. Before leaving, I'd seen reports of this strange new virus that was starting to cause concern. Nothing to worry about, I thought. I went to my first appointment on the Monday morning, emerged, switched on my BlackBerry, and it suddenly lit up with messages and missed calls galore. My entire diary for the week had been cancelled as companies locked down and banned outsiders from entering their offices. Training courses, meetings, cancelled en masse, thanks to SARS. With nothing in my diary and my travel expenses covered, I had the most fabulous week's holiday, oblivious to the virus raging around. 800 people died, and I had a great vacation. Looking back now in 2021, you can imagine I feel a bit guilty. You know, last year started so brightly. Here's an event I chaired at the Royal Society of Arts in London in February called Proposals 2020 for 100 directors of bidding from different organisations. Upbeat, filled with optimism. If only we'd known. They say that 2020 means perfect vision, and the worldwide crisis we've all been through has certainly brought a lot of things into sharp focus. We've been in tough times for so many organisations. The pandemic has been catastrophic for some bidding organisations and their people. Meanwhile, other firms have never had it so good in terms of workload and projects, meaning their staff have been stretched to their absolute limits to meet soaring client demands. Individually, many have been challenged to find the right life-work balance, especially perhaps those with very young kids or those attempting to help with the maths homework. Many in the bidding profession have battled with their mental health and well-being. When in a survey we asked last year, people working in bid roles in the UK, how are you personally feeling right now? And asked them to rate themselves on a scale of 0 to 100, 1 in 12 scored themselves below 20. There are a lot of people out there who have been, who are really struggling. And that's even before we get to the people who've lost those dear to them, those who've suffered themselves from the virus, those who've cared for sick loved ones, who've not been able to spend time with elderly relatives thanks to lockdown. I think I've probably depressed myself. So based on our research, based on discussions with successful bid teams out there, what are some of the things that we now consider in these changing times for bidders moving forward? I'm going to touch on 10 areas. I've long argued that people buy from people they know, like, and trust. Nigel Hudson, one of the most insightful people I know in the sales world, commented in one of our recent research surveys that it's now a case more of people buy from people they know, like, and have never met. The Harvard Business Review once said that trust needs touch. And to quote Professor Yossi Sheffi at MIT, whose book, The New Abnormal, is one of the best things that I've read recently, there's still no substitute for personal contact when it comes to building business relationships, and that's unlikely to change in the foreseeable future. So let's play this out. By the time it came to writing a proposal in the olden days, by which I mean up to March last year, I'd have hoped and expected that my salespeople, solution team would have spent quality time with the client over a period of months, that they built great rapport with the key stakeholders, that they talked, of course, but most importantly, had listened. I want my proposal to be sown onto fertile ground. Now, you're not going to get near the client's office. Stranger danger, unclean. Even if the client's in the office at all, of course, they're more likely to be working from home, and they're not going to invite bidders round for a cup of tea in their front room. And so the ability to form people with bonds online, well, I'm told it works on Tinder. I'm not sure it's quite so true in the world of business development. So no matter how good your sales colleagues get at online prospecting and online meetings, we'll be faced when we write a proposal with a trust deficit. And how do we deal with weaknesses in bidding? We mitigate, we counter, we address, we downplay. Your proposals are going to have to do a whole lot more about the team who've designed the proposition that's so beautifully articulated in your document, to breathe life into their skills and experience, the process that they've gone through, the debates, the discussions, the decisions that have led to you being confident that your proposition is the best possible being put forward. They'll need more too about the team that'll work with the client once selected, because the client won't have met them face to face. Their background, their style, what makes them tick. Quotes and anecdotes, making the two-dimensional feel real, breathing life into the names on the page. And they'll need to address how you'll go about building real rapport with the client's delivery team, especially when that has to be done remotely. We need to think proposals circa 2019, but with a far, far greater human touch. When it comes to winning business, you need a clear strategy, and that revolves around the 3 C's of customer, capability, and competition. It's by analyzing those that you get to your compelling story, the why us, why not them, the 3 main win themes that you're going to weave through your document like golden threads. As my friend and colleague Richard Bous of Strategic Proposals team in the Netherlands puts it, now from a strategy perspective, it's not just about those traditional 3 C's. There's a 4th C that you can use to be distinctive: coronavirus. Showing true empathy in your bids with how the client's world has changed, how it will continue to change, and the flexibility they'll need moving forward will become a true secret of success. And some of us on the call, some of the older ones of us, or shall I say more seasoned, will have worked through the last recession. What happens if there's a macroeconomic downturn, as there may be? Clients have less money to spend. They spend it on necessities, not niceties. Debates in bidding move towards cost reduction and retrenchment. Volumes go down, and salespeople get more desperate. It's the old scenario explained by my colleague BJ Lowney, who founded Strategic Proposals in the States, that if a salesperson happened to stumble across a copy of an ITT lying on the side of the road, they dust it off and probably want to bid. Tough targets, limited opportunities. Hey, let's chase anything that moves. Taking robust bid, no bid decisions is always critical. It's even more so in straitened times, where you really can't afford to waste your time on ever more precious hours chasing ever more lost causes. Lorraine, one of my team, nailed it recently, I think. The most successful people now will be qualifying, qualifying, and qualifying again. I know we have people in procurement on the call. I don't think the average buyer right now is jumping with joy at the prospect of running tendering processes for any of their contracts that are due to expire in the coming 12 months. Of trying to build consensus amongst their internal stakeholders on new requirements, on the evaluation criteria, on their ITT questions, and having to coordinate an evaluation process remotely, comparing scores and notes across endless online workshops, and having to actually implement change, trusting that their chosen vendor really can deliver the solution remotely, or having to put in place arrangements to bring them safely onto site to do whatever necessary to move away from their existing supplier. As a former procurement professional myself, it's not often I feel sorry for those who still work on the dark side, but actually I do right now. So might perhaps it just be a case, the buyers would be better suited, where possible, under the rules they're following, to strike a great deal to extend the contracts of their existing suppliers within whatever contractual frameworks might allow that, nimbly adapting to reflect their changing needs or usage patterns as a result of the pandemic, and to build in more flexibility for the future unexpected. It simply can't be the case in 2021 that winning new business should still be seen as glamorous by bidding organisations, or as more glamorous by bidding organisations than protecting the jobs and revenues associated with current clients. And so I'd argue that in the current climate, renewal proposals should perhaps be the primary focus of most proposal teams. Let's get off the back foot. Let's stop waiting for ITTs to land from clients who'd really rather not have to issue and evaluate them. And let's get creative by putting forward some cool propositions. Everybody can write. Many salespeople, many bid managers can turn a phrase. But even in the bidding profession, very few people indeed are truly brilliant wordsmiths. The art of making subject matter experts sound more eloquent than they ever thought they could be is a rare skill indeed. And I'm going to argue that as we submit more of our content online, have less time in which to capture the evaluators' hearts as well as their minds, potentially see decisions taken more on the written proposal with no form of pitch or interview, that as we move forward, the skills of the brilliant proposal writer and editor will become even more in demand. To quote a fascinating thread on Twitter last autumn, documentation is the unspoken superpower of remote teams. The most successful team members remotely will be great writers. Do you have great writers in your bidding organizations? Design has moved faster than almost every other aspect of proposal development over the past decade. I look back last year at the winning entries from a competition I'd run in the UK for proposal design just over a decade before, and trust me, your bid looks very 2008 isn't a compliment. Fast forward 12 months, and I'm going to argue that your proposal looks very February 2020 isn't a compliment either. Back then, a year ago, if you submitted your bid electronically, the evaluators probably printed it to review. Now, we know they probably don't have a high quality laser printer nestled under the kitchen table where they're working. If you've not given real thought as an organization to how you make your proposals more accessible on the screen, you're falling behind. And it's not just about the need for radically better, different design for traditional proposal documentation. We're seeing more and more demand for videos, for animation, for creative ways of having your proposal conversation with the client in a world that's changed. Executing that quickly becomes increasingly critical too, and doing so earlier in the sales cycle. You hold an online meeting with a new prospect, they're not going to want to wait 3 weeks for the follow-up or to simply receive something generic. As I've long argued, people see what it looks like before they read what it says. And if your proposal team lacks real cutting-edge design skills and the ability to execute at proposal speed, your competitors will by now be stealing a march on you at every turn. We all get that death by PowerPoint was a nightmare face-to-face. Over Teams, it's a calamity when it comes to bid presentations. And so I just want to ponder two particular challenges of virtual pitching. Number one, the best bid teams long ago moved away from talking about their proposal presentations in terms of slides and scripts to thinking about what we term the experience in the room. It was moving away from the evaluator sitting there looking up at a screen to them connecting with you in more of a holistic way. Posters to get them standing up, thought-provoking material in front of them on the table in the room, or at times no collateral at all. So the first challenge, how do we create a more rounded experience in the room when we're not in the room? It's something that takes real thought and skill, but which can create real differentiation. Number two, have you ever worked with a bid team that's done the first run through of their presentation in the coffee shop opposite the client's office an hour before? Now we're remote. To quote Larissa Cornelius, who runs Africa's leading bid consultancy, virtual pitch sessions are far more unforgiving. So strong rehearsal for online pitches differentiate the strongest pitch teams. Now that's important more than ever before. From virtual virgins to a zest for Zoom, this year's seen so many of us thrust into a world of online collaboration. It's one of those things that people will discuss when dinner parties become a thing again. What did you use during the crisis? I was a Zoomista. Here's Tilly, one of my two wonderful Maine Coon cats. Anyone who's been on a call with me over the past year will have met her. She's taken up pretty much daytime residence in the space between my keyboard and my monitor. You know, if a year ago my cat had come purring and meowing into a call, into a meeting, people would have frowned at the utter unprofessionalism of it all. Now they look forward to her appearance. One of my favorite songs in the 1980s was by Depeche Mode. It was called People Are People, and it feels like we've all recognized that at last in our professional lives. To quote my good friend Nigel Dennis, the leading bid expert in Australia and New Zealand, we've been introduced to partners we didn't know, animals we didn't know existed, and to little humans with chocolate smeared over their face. That's all just great and builds stronger connections. And yet, as we've become more attuned to the human dimension of the teams we work with, we've become less attuned too. Want to chat to your boss? Schedule a session on Teams. Want to catch up with a coffee? Put a virtual with a colleague. Put a virtual coffee in the diary. Need to speak to someone senior? Submit a written request for a WebEx meeting rather than catching them in the cafeteria. And that's when you know you want to speak to someone. Some of the most magical, motivating conversations about bidding I've had at work have been those water cooler moments with people you didn't even know you needed to talk to. As Janneke Oriens, one of the directors of our Dutch business, commented, formal meetings never were the most effective way of communicating. In the world of remote working, as McKinsey put it in a recent article, serendipitous interactions no longer occur. In this new world of ours, we're learning that we need to work at spontaneity. And you know, I've attended so many very ordinary virtual meetings in recent months. Here's the thing, being really brilliant with whatever tech your organization's adopted will differentiate the best bid teams from the merely mundane moving forward. And when you're working virtually, you need to find out the right way to work. You need to find ways to be kind to yourself, find the time to take a walk, to go for a coffee, to plan a fake meeting for your lunch break, as someone said in one of our surveys. To remind your organization that working at home on bids doesn't mean always on. And by the way, when we're talking about about systems and working from home, potentially surrounded by strangers, by housemates, security, anyone? The lawyers in the room must be having sleepless nights right now. 5 days a week in the office with the occasional opportunity to work from home. It's not going to be like that moving forward. Will it be 2-3, 2 days a week in the office, 3 at home, 3-2, all at home, save for particular dates when we need to come together? It will vary from organization to organization, from team to team. But I'm going to insist that there are some activities in the bidding process that really are done best face-to-face. The team building stuff, the strategy stuff, the storyboarding, very probably some reviews. We can replicate or parody the face-to-face experience as well as we can online, but there will be no real substitute for real meetings to unlock winning ideas when a group freewheels together within a great structured process in the same room. So here's the challenge. How do we optimize the mix? And if time in the office is precious, not given, how will we use it brilliantly when it comes to bids? I think that's a huge challenge and a huge opportunity for the bidding organizations who get it right. And then, while so many procurement and bid teams are battling to stay afloat in the middle of all the chaos, the government decides it's the right time to implement the most radical changes to public sector procurement procedures in a generation. Fabulous. Now, Chris and Emma are far more expert than me when it comes to the detail of the green paper, the construction playbook, and other new changes, but a couple of perspectives. Let's be positive first. There is much to like in the government's proposals. Reducing the multiplicity of sometimes conflicting regulations, making simple procurement simpler, which goes hand in hand with opening up access to a more diverse supply base. Acceptance that lowest price is not always the right answer, and that the public good should routinely play more of a part, routinely and genuinely. The focus on social value is absolutely to be applauded. And despite some well-known failures, I applaud the pace of procurement in the pandemic. It's good, though, to see learning from that embedded in the new processes for crisis procurement. The need for bidders to respond to tedious requests for mundane corporate information in slightly different formats for every single bid, replaced by a tick of the box with the central locker. The move to clearer pipelines, earlier engagement, fabulous. But I have reservations too. While there are so many people in the public sector who are doing wonderful work, often in hugely demanding circumstances, the bid and proposal teams I work with are on the receiving end of far too many mediocre ITTs. There's too much inconsistency, often too little correlation between the value of the deal, the size of the prize, and the complexity of the ITT being sent out. We see radical differences in the sourcing approaches adopted by different contracting authorities, sometimes down the road from one another, buying fundamentally the same things in the same local communities. And poor procurement practice, poor ITTs rarely draw out the best from suppliers or therefore deliver the best for the taxpayer. We feel even that as bidders, we're on the receiving end of a process that's sometimes shaped by an underlying culture of mistrust from the public sector towards the private, rather than of genuine partnership. Other than some commitments in the Green Paper to significantly upskill public sector procurement teams, none of those concerns are really addressed here. More fundamentally, we have a 78-page paper proposing reform, which comes with absolutely no quantifiable business case. The public sector procures £292 billion of goods and services a year. Is it too much to expect to see details of the savings and social value improvements that we could expect to see from these radical changes? The return on investment, to be shown the key performance indicators by which they'll measure success, not addressed at all, or worst case, hidden away. It really concerns me. Finally, I'm going to leave the last words to a few of those directors of bidding who responded to some of our surveys in the past 12 months. I'm not sure I can add much to them. The virus probably marks the end of an era of indulgence. They continued, it's going to force smarter working with leaner and more virtual teams. Change creates opportunity. We just need to be smart enough to see it and agile enough to exploit it. Are your bidding organizations truly agile and truly looking at how they're going to exploit the opportunities? Because now is the time to put our energy into thinking about next generation bids and proposals. And of course, bid and proposals are fundamentally a competitive activity. Those teams that will thrive in the new world will be those who react quickest to the new ways of working. If your bidding teams are operating now as they did 12 months ago, they probably need to start thinking very quickly about how they adapt, how they change, and how they move forward in a world in which procurement people will procure differently, will absorb information differently, a world which will get ever more competitive. Perhaps for all of those of us involved in winning work, it's time to wake up and smell the coffee, assuming, of course, that you haven't lost your sense of smell to the virus. Two more comments from our first survey that I've personally found really useful in the past year. Number one, focus on the things you can influence. There is so much out there that could cause chaos, confusion, and upset, and that really thinking about this is important. And hang on in there, we will get through this. 10 areas that I think the most successful bid teams need to be thinking about in this strange, brave new world we find yourself in. Thank you so much for listening. Stay safe. And if you have any questions, I would love to chat to you. Just drop me a line. So thank you, everybody.
Thank you very much, John, for those excellent insights. There's certainly a lot of ideas for all of us to think about who are continuing to work from home and carry on business virtually. That does bring an end to today's webinar, and we hope there's been something of interest for everyone, whether you're a bidder or a contracting authority. Thank you also for all the questions submitted during the webinar. We'll aim to answer these as soon as possible after the webinar. And of course, if anyone does have any questions about the issues we discussed today, please feel free to contact Emma, John, or myself on the email addresses given on this slide. We'll be sending out copies of the slides and the presentation, a link to the presentation afterwards. And that just leaves me to say thank you to everyone who attended, and goodbye.